This is the second part of the lecture for sale of goods. Previously, we have discussed definition of the important terms such as goods, sale of goods, and price. We've discussed terms of contract, which includes conditions and warranties, sale by description, suitability and quality of trade, and sale by sample. Now we will proceed with the remaining discussion. The discussion includes sale by non-owner, rights of unpaid sellers, remedies for the buyer, and remedies for the seller. The first one, we will discuss sale by non-owner. So there is one maxim, nemo dat quod non habet, or what we call as nemo dat rule. It means that a person who does not own a good has no right to confer it to another person, except with the permission from the real owner of the good. So if A sell a car belong to B to C, C does not get the ownership of the car because the car does not belong to A but belongs to B, even if C is a bona fide purchaser. The principle is stated in Section 27 of the Act, and the objective of this principle is to protect the real owner of the goods. The case that illustrates this principle is the case of Lim Chui Lai, where in this case the court held that Ahmad was not the owner of the materials after MPPJ cancelled the contract because the materials belonged to Zeno Limited. Ahmad was a bailee who kept the materials and he had no right to sell it to Lim Chui Lai. This case applied the maxim of nemo dat. So that is the general principle. However, there are exceptions to this general principle. As you can see from here, there are 6 exceptions. First, estoppel or impediment. Estoppel is one of the laws under the English law. It's under equity. It means someone is prevented from saying or doing something that contradicts to what he has said before. In the context of sale of goods, for example, let's say A, he is B's father. A allows B to use his car as if the car belongs to B. B has used the car for 20 years. A even told others that the car is B's car, even if it is actually belong to him. Then one day, B sell the car to C for 5,000 ringgit. When A finds out, he asked the money from B, but B refused to give it. A brought an action against C, claiming back the car. In this situation, if we apply the general principle, C has no right over the car because B, the seller of the car, is not the owner of the car. However, this case falls under exception number 1. Under this exception, A is estopped from claiming the car because he had allowed B to use the car for almost 20 years and even told everyone that the car belonged to B. C is under the impression that B is the owner of the car. In other words, C can apply estoppel from the court. For another example, you can read the case of Syarikat Batu Sinar versus UMBC Finance. The second exception is sale by mercantile agent. So who is mercantile agent? You can read section 2 of the Act. There's definition of mercantile agent. It is defined as agent that have authority to sell goods or to consign goods for the purpose of sale or to buy goods or to raise money on the security of goods. While the proviso to section 27 states the conditions that need to be fulfilled before the exception is applicable. The conditions are: number 1, the seller must be an agent. So, he must be the mercantile agent. Number 2, the mercantile agent must be in possession of the goods. Number 3, the possession must under the consent of the owner. Condition number 4, the seller must acting in the ordinary course of business. And lastly, the buyer must have acted in good faith, and at the time of the contract of sale, the buyer must not have any knowledge or notice that the agent has lacked capacity as an agent. If fulfill these 5 conditions, then the sale of goods by the mercantile agent is valid and there is transfer of property to another party even if the mercantile agent has no ownership over the goods. The third exception is sale of goods by joint owners as stated in section 28 of the Act. Under this section, if a good is owned by several owners, the joint owner can sell the good provided that it fulfills condition as follow. So the seller must, number 1, be one of several owners. Number 2, be in sole possession of the goods with the consent of his co-owners. And number 3, sell the goods to a bona fide purchaser who is not aware of the seller's lack of authority at the time of the sale. The fourth exception is sale under a voidable contract as stated under section 29 of the Act. So we've learned about voidable contract before. By virtue of section 29, the transfer of goods is valid if the seller obtained the goods from a voidable contract, but the contract is not cancelled or rescinded when the seller sells it to the current buyer. There are few conditions before the sale is said to fall under the exception. So the conditions are stated in this section, i.e. section 29. Number 1, the seller of goods has obtained possession under a contract voidable under section 19 or 20 of the Contract Act. Number 2, the contract has not been rescinded at the time of the sale. And number 3, the buyer buys the good in good faith and without notice of the seller's defect of title. Okay, these are the conditions before the sale is said to fall under the exception. You can read the case of Car and Universal Finance. So this case did not fulfill all the conditions as stated in section 29. I repeat, it did not fulfill all the conditions. So in this case, Caldwell, the seller of the Jaguar car, has obtained possession of the cheque from A under a contract voidable. So this fulfilled the first condition. However, the contract has been rescinded at the time of the sale because Caldwell, the seller, immediately made a police report and terminated the contract between him and A. So, the second condition was not fulfilled. And the buyer buys the good in good faith and without notice of the seller's defect of title. So, the third condition was fulfilled. In this case, the second condition was not fulfilled. So, the transfer was not valid and the plaintiff cannot claim the title because it not falls under the exception. Okay. Next, the fifth exception, sale by a seller who has possession of the goods. This is stated under section 30, subsection 1 of the Act. The conditions are also stated in the same section. There are 5 conditions. Number 1, the seller sold the goods and passed the goods title to the buyer. Number 2, the goods still under the possession of the seller. Number 3, the same goods are sold to the second buyer by the seller. Number 4, the second buyer bought the good in good faith without the knowledge of the first transaction. And lastly, the second buyer will have the ownership to the goods. For example, you can refer to the case of Pacific Motor Auctions, where in this case, the seller, i.e. the agent, sold the cars owned by the plaintiff to the defendant. At the time of selling the cars were still under the possession of the agent and the same cars were sold to the defendant. The defendant bought the cars in good faith without the knowledge of the plaintiff cancelling the contract with the agent. Due to these facts, the defendant has the ownership of the cars. The last exception is sale by a buyer in possession of the goods as stated under section 30, subsection 2 of the Act. Based on this section, the buyer in possession gives good title to an innocent buyer. You can read the case of Newton's to understand this exception. Okay? In conclusion, the general rule is that the buyer who bought goods from a non-owner will not get a good title, i.e., there is no valid transfer of the ownership of the goods. This is based on the maxim of nemo dat. However, there is a valid transfer of the ownership of the goods if the case falls under any one of the 6 exceptions that we've discussed before. So that's the end of the discussion on sale by non-owners. Next, we will discuss rights of unpaid sellers. So who is an unpaid seller? You can read section 45, subsection 1. The seller is deemed to be an unpaid when he has not received the whole price when a bill of exchange or other negotiable instrument has been received as conditional payment and the condition on which it was received has not been fulfilled. The 3 rights of unpaid sellers are stated in section 46, subsection 1. The first right is right of lien, which is right to hold the goods until payment is made. Okay? Under section 47, subsection 1, the unpaid seller who has possession of the goods can retain the possession until payment is completed. While section 49, subsection 1 is about when the unpaid seller lost the right to lien, i.e. the right to keep the possession of the goods until the payment is made. You can read the 3 situations stated in the section. Okay? The second right is the right of stoppage in transit. Section 50 gives the right to an unpaid seller to stop the goods which is in transit until payment is made. For example, let's say there is a contract of sale of face masks between A and B is supposed to pay 50 ringgit to A before receiving the face mask. A already paid cash and sent the face mask to courier to be sent to B, but later found out that B has not paid 50 ringgit yet. So, A has a right to stop the transit. Okay? That's the example. The third right is the right of an unpaid seller to resell the goods as stated in section 54. Let's say A and B enter into a contract of selling vegetables. B fails to pay and A has a right to resell the vegetables. So in conclusion, there are 3 rights of unpaid sellers as provided in section 46 subsection 1 of the Act. Now we will discuss the remedies for the buyer and seller if there is a breach of the contract for sale of goods. First, if the innocent party is the buyer. Example, A, a seller, and B, a buyer. A fails to send the goods as promised to B. B, the buyer is entitled to few remedies. First, B can brought an action to the court and claim damages, i.e., monetary compensation. Second, B can apply for specific performance to force A to send the goods to him. Third, B can just reject the goods if there is a breach of condition, i.e., the failure of sending the goods to B on time. Lastly, B can just refuse the goods. If the innocent party is the seller, example A, a seller, and B, a buyer, let's say A send the goods as promised to B. However, B, the buyer, failed to make payment. A, the seller, is entitled to few remedies. First, A can bring an action against B in the court to claim the price of the goods that are supposed to be paid to him. Second, A can also claim damages from B, i.e., monetary compensation. So these are the rights of a buyer and a seller. That concludes the discussion on the sale of goods. Thank you.